before we begin, I hope everybody has in their heart what happened not that long ago on this date, and then I hope that we can all be unified as a nation as we think about the events of September 11th. So, that being said, this is today's meeting of the Cocoa Beach Special Magistrate, Code Enforcement Special Magistrate. I am fairly observant, even though I just had my 74th birthday. I realize there's not a whole lot of people here, but I understand that we are streaming this and recording it for others to see. So I'll briefly, if anybody happens to watch, go through the process. This is a quasi-judicial process. This is not a public hearing process. So we have two sides in these cases. One is the city, who has alleged that there's a violation of a code enforcement, of a code of the city of Cocoa Beach, and there's a respondent who's usually the property owner who has been alleged to be in violation of the code. And during the course of the hearing, the city presents evidence and the respondent presents evidence, and they have the right to cross-examine each other. And at the end of the proceeding, I make an oral announcement of my decision, and then within a few days thereafter, I issue a written order. And I thought I had told this phone to be quiet. I'm going to do better than that. I'm going to turn it off. So, like I said, this is not a public hearing, so it's all between the parties and those witnesses whom they call. And so, we're obviously in the sunshine. Cocoa Beach adheres to the sunshine law very well, and anybody can come and watch these proceedings. Obviously, watch them after the fact, or watch them from their home, the convenience of their home. All right, that being said, are there any other preliminary matters besides what I just articulated?
Only if, Michael, could you hit the audio button so that yes, thank you so much.
Well, you just mentioned something. To my right is Michael Bryan, who's serving as clerk to these proceedings. So, and you just came on board in Cocoa Beach when? June?
June, yeah.
Okay. All right. So I'm present. Do we have any minutes today?
Yes.
We do? Although it may seem odd that we're approving minutes because I'm just me and not a body of any type. The Florida Attorney General has said that the minutes of these proceedings must be taken and maintained. And I'm looking at the minutes of the July 10th, 2024 meeting, which I have reviewed previously, as I recall, and I'm approving those minutes. Thank you, Mr. Bryan. All right. So the first case today is a new case, case number DSCE 24-46. Respondent is Min Chi Ta and Van Tai Lee. The address of the property is 5840 North Atlantic Avenue. Is the respondent present?
It doesn't appear so, no.
Is the respondent present? I don't have to have the halls called because I can see the halls. So I see no person in the halls, and I'm asking for the third time, is the respondent present? The respondent's not present, you may proceed.
And I believe we also need to be sworn in.
Excuse me?
Sworn.
Oh, that's right. That's what I forgot. Anybody who plans on testifying today must testify under oath. So aside from Ms. Crawford, let's start over here. Would you state your full name, please? Yes, ma'am. Okay, and you are?
Danielle Crawford.
And?
Javier Massa.
Each of you solemnly swear that the testimony you're about to give in the matter of now hearing will be the truth, the whole truth, and nothing but the truth to help you God.
I do.
Thank you. Thank you for reminding me.
All right.
All right. Now you may proceed.
Okay. So as you just stated, the property owners are Min Chi Ta and Van Thi Lee. They are the property owners of 5840 North Atlantic, which is both the property, and they are also the owners of the business Tokyo Japanese Steakhouse. So we have property search and we have Sunbiz reflecting that information. On slide 5, you'll see that we believe that they are in violation of section 13-21, doing business without a license, and we asked them to renew their business tax receipt with the city of Cocoa Beach. On slide 6, I first sent the courtesy notice mailed March 25th, 2024 via first class mail. On slide 7, I then sent the notice of violation April 18th via first class mail, as well as certified mail on April 19th. The courtesy letter essentially explaining in further detail what needed to be completed was sent on May 10th via first class mail. We did eventually receive the green card for the notice of violation on May 13th, 2024. We still had no contact from the respondents, so I reached out via email, again with the notices, the courtesy letters, just asking them to renew their business tax receipt. There was no response. I then sent the notice of hearing, mailed July 11th, 2024. This was sent via first class mail as well as certified mail, July 11th and July 12th. I went ahead and posted the notice of hearing at the property address as well as City Hall on July 12th. The next slide shows the affidavit swearing that I personally completed this task. At this point, the manager of the restaurant, we believe, opened a renewal in our portal. So I reached out to this applicant on August 7th via email, as well as on that portal. Again, just saying, you know, we're more than happy to just get this closed, get it worked out, cancel the special magistrate, no offense. And still no response. So this is just the expired business tax receipt showing that it expired September 30th, 2023 for the business Tokyo Japanese Steakhouse. This is the fee that is owed to the city. I believe we already have all the documentation we need, as long as that documentation isn't expired as well. The next slide shows that the business website showing that the steakhouse is open 7 days a week. They are in business actively. The next slide is Google reviews, review as recent as September 9th. And so that is all of my documentation. And essentially the city's just asking that they be ordered to renew their business tax receipt.
Okay. Did you want to introduce the PowerPoint into evidence?
I would.
Okay.
Thank you.
Okay. And this consists of the documents which you've shown on the screen?
Yes.
Thank you. The respondent not being present. This was a good test of my new glasses. I could read everything.
Okay.
It'll be admitted. As composite exhibit A. So what time frame do you suggest for compliance and what fine do you suggest?
I would ask that they be found in violation of section 13-21 and maybe 30 days to come into compliance.
Now, this is the local this is the local business tax you're talking about, right?
Yes.
Okay.
And then I was just suggested that we assess a fine for if they do not come into compliance.
Yeah, as I recall, the statute, doesn't it limit it to a certain amount of fine?
It can't be greater than 500 a day.
No, it's, what is it, chapter 205? I'm trying to remember. I think the local business tax statute. And I think the Attorney General has discussed that in an opinion, as I recall. Ms. Vos, did I remember the chapter correctly?
Yeah, I'm.
Oh, my gosh.
Looking here. It's subject to a penalty of 25% of the tax due, in addition to any other penalty provided by law or ordinance.
Okay, so it's not a set dollar amount anymore.
I'm not seeing it.
Is there a section that says late payment or something like that?
No, the word late isn't in
Okay.
that chapter.
Okay, then the legislature must have changed it. So under the statute now, the maximum penalty is 25% plus any amount,
Okay, here, under penalties.
penalty, there you
It
go.
says, yes, receipts that are not renewed when due and payable are delinquent and subject to a delinquency penalty of 10% for the month of October, plus an additional 5% penalty for each subsequent month of delinquency until paid. However, the total delinquency penalty may not exceed 25% of the business tax for the delinquent establishment. So it.
There's not an additional $100 or something like
And it
that?
says any person who engages in any business or occupation or profession, if they don't do it within 150 days, including court costs, reasonable attorney's fees, additional administrative costs incurred as a result of collection efforts, and a penalty of up to $250.
250. That's it. So how late are they now?
Almost a year.
Year, okay. So with the maximum of $250 plus the other charges, if you can assess those, is it your desire to have the maximum assessed?
I think so.
That's
I
my
mean,
experience at any rate. That's my experience, but I don't know
it should be.
what you, okay. All right, and that is an immediate judgment, I suppose, if it's recorded, so anyway. All right, so is there anything further?
No.
Okay, so I'm going to find in case number DSCE 24-46 that the respondent is in violation of section 13-21 of the city code of ordinances, that they have violated the code as alleged by the city, and that, well, let me ask you this. Do you want the fine even if they come into compliance in 30 days? Or you just want the fine, period?
Yeah, yes, I think so. The fine of $250.
Because that would just, there's no compliance date then, it's just there is a fine.
Yes.
Is that, okay? And that the respondent is fined the amount of $250, which is due and payable, together with any other fees and costs assessed by the city under controlling law at the time the order is issued. Is that what the city desired?
Yes.
Okay. All right. Then I'll enter an order on that case that way. The next case is DSCE-24-136. The respondent is Rachel Aragon. And the address of the property is 645 South Atlantic Avenue, Cocoa Beach, Florida. Ms. Aragon? What was the lady's last name? Was that her behind?
That was not.
That was not. I can't hear in this echo so good, so. And I'm probably talking way too loud, so I apologize for that. Rachel Aragon. Rachel Aragon, I'm looking in the halls again. I see no Rachel Aragon. I've called 3 times. The city may proceed.
I would like to enter the packet into evidence.
There being no objection, this will be entered as the city's composite Exhibit A.
All right. As previously stated, the respondent is Rachel Aragon, the property owner of 645 South Atlantic Ave. Essentially, we are here today because she's running a vacation rental property since March of 2022 and has never registered the property with the city. So on slide 3 here, you'll see that she is the property owner, and she did purchase the home in 2022. On slide 5, we believe that she is in code violation section 13-2, license permit required, with a corrective action to obtain the BTR for the vacation rental business. On slide 6, we believe that she is in violation of section 26.5-21, registration required. Because the vacation rental is within the RS1 zone, she is required to have the RS1 registration. The corrective action would be to obtain that RS1 registration. On slide 7, we believe that she is in violation of section 26.5-53, maximum occupancy, as she has, her listings were previously listed at 13 guests, with our code stating that the maximum occupancy is 8. On slide 8, you'll see that I first sent a courtesy letter as well as a courtesy notice together on June 5th, 2024. So here's the courtesy letter. Next is the courtesy notice, essentially just stating to come into compliance. The notice of violation was sent via first-class mail on June 27th. And then certified mail, oh, my signature got cut off, the following day, June 28th. The green card was never returned. There was no communication from the property owner. So I went ahead and posted to the property address as well as City Hall on July 22nd. I then completed the affidavit of posting. The notice of hearing was then sent again after no contact from the homeowners. It was sent via first-class mail on August 23rd and certified mail on August 27th. When they received this, they did begin their application on the portal on slide 18. You can see that we did have very brief contact with the property owner. However, no documentation was provided, the fees are unpaid, and we have not heard from her since that date. Again, just got cut off, so I had to add it to the next slide. The notice of hearing was then posted to the property address as well as City Hall September 9th. I completed the affidavit of posting. And then on the next slide, we get into the evidence. We use a system called Rentalscape to pool unregistered vacation rentals within our jurisdiction. Rentalscape, it essentially shows the 2 live listings with links to the actual live listings. It shows her daily rate. It shows days booked. And On the next slide, the live listing for Verbo. This was pulled from data on June 5th. This listing has since been removed. And the listing at the time stated that it allowed 13 guests, which is over occupancy. On the next slide is the Airbnb listing. Again, it's a live listing showing an allowance of 13 guests. This has since been reduced to 8 guests on the next slide, where you can see that the listing is still live. They are still taking new reservations. However, the occupancy has been reduced. On slide 26, you see the Airbnb reviews. These first 2 reviews are from April and March of 2022. And the following slide shows the most recent reviews in July of 2024.
Okay. So what I understand is, and the respondent's not here, is to repeat what you said. Although it's a different section of the code, they haven't gotten paid their local business tax.
Correct.
They haven't registered as a vacation rental.
Correct.
They were renting and offering the property for rent with 13 occupants, and now they changed it to 8.
Yes. Yes.
So your assertion is that they are in violation of not getting paying the local business tax. They are in violation of not registering the property as a vacation rental, and they were in violation after the time they were told to be in compliance, but they've come into compliance about
Yes.
8 occupants.
Yes.
So we've discussed about, in the prior case, about the maximum fine for the local business tax. So that's what you want for the city wants for the
Yes.
local business tax violation? What does the city suggest for the registration?
That is a good question. Thank you.
Becky Vo, City Attorney. We would recommend $250 a day fine. And give them 10 days to come into compliance.
And that's based upon the lack of cooperation that's been received.
Yes.
And as to the maximum occupancy, since they're in compliance, would you want a no fine standing order in that so that it would be a repeat violation?
Exactly. I would like for you to find them in violation, find them to have been in violation, so that when we come back, we can assess a bigger fine.
And for those who may be observing these proceedings, that is a very normal thing for a city or county to do in these types of situations. When a person has not adhered to the opportunity to be in compliance at the time instructed, and yet they become into compliance prior to the hearing. There's no fine assessed, but the next violation would be a repeat violation. So that being said, I'm going to find that there is a violation of section 13-2, that the maximum statutory fine of $250 is assessed together with whatever fees, costs, and charges that the city may impose in accordance with its code, that there is a violation of section 26.5-21, and that the respondent shall have 10 days from the day of the order to come into compliance by adhering to the code, and if they don't, a fine of $250 per day will commence, and that the respondent was in violation of section 26.5-53 after the date that the respondent was advised to come into compliance, but that the respondent has come into compliance prior to hearing, and that any future violation will be treated as a repeat violation under the provisions of the controlling statute. Is that basically what the city's requesting? That's what I'm going to order.
Yes, sir.
Okay, the next case is case number DSCE 24-203. The respondents are Mark Soft Jr. and Mandy Thomas. The address of the property is 104 West Leon in Cocoa Beach, Florida. And I forgot your name again.
Nathan Molina, on behalf of the respondents.
I met you before, okay, and you're representing the respondents.
Yes, yes.
Okay, then the city may proceed.
And then we wanted to give them an opportunity to look at the evidence.
Would you like to look at a copy of the PowerPoint?
Yes, that would be greatly appreciated.
Do I present it to you as well?
You have an extra?
Yes.
Okay, sure. I can wait. That's good. So, Mr. Malone, what we'll do is we'll treat it as just demonstrative evidence as Ms. Crawford goes through the proceedings. And then if she asks that it be considered as documentary evidence, we'll decide at that time. How does that sound?
That works.
All right, you may proceed, Ms. Crawford.
All right. You want me to proceed through okay. So we're here for DSCE 24-203. The respondents are Mark Soft Jr. and Mandy Thomas, owners of the property 104 West Leon Lane. This is the property search showing that they are the owners. All right. This is just the warranty deed. You want to click through, just showing again that they're the owners and that the home was purchased in 2020. Just some tax receipts. Yep. So we believe that they are in violation of Code Section 6-4C permits. Permit and permit fee required, and this is for construction work. We asked that the respondents obtain permits for the unpermitted plumbing work, electrical work, and the windows that were turned into doors. I sent the notice of violation July 31st, 2024. This was sent first class and certified. The green card was not returned. No permits were submitted, and we did not receive any contact from the owners. So I went ahead and posted the notice of violation to the property address as well as to City Hall. Next slide is the affidavit. On September 4th, the notice of magistrate was sent via first class mail and certified mail the same day. I went ahead and posted it to the property address as well as to City Hall, just preemptively assuming I wasn't going to get the mail is usually returned. There's the affidavit of the postings. And so today we're going to be talking about these 3 locations within the house. So this is a diagram that was submitted previously when they were doing vacation rentals. They have a sliding glass door, another sliding glass door, and a kitchen listed on the diagram. So this is self-disclosed information. On slide 22, you see a large black window. This is taken from the 2019 MLS. On the next slide, you see the same large black window next to the same white door, taken from the 2020 MLS. And finally, you have a large sliding glass door with a step added. This photo was taken when we did the property inspection on May 30th, 2024. So we are alleging that that black window was turned into this sliding glass door, for which there are no building permits. This is the same sliding glass door from the inside. This photo was taken from a video from the respondent's vacation rental website. Here's the same window before. So it was a sliding glass door, now it's a window. On the next slide, you see the same room. It's a large empty room. And if you click the next slide, there's now a kitchen. If you click the next slide, so in this kitchen, you can see the sink was installed. Electrical was installed for the floating microwave. So this would be for the plumbing work and the electrical work completed without permits. And now we come to the last sliding glass door. Again, this photo was taken from MLS 2019. You'll see a large window. Now you see a sliding glass door. And if you click to the next slide, that same sliding glass door from the outside, again observed by me and Javier on May 30th, 2024. The last slide is a text message from a realtor who is present today via Teams. She received this text from Mandy Thomas stating essentially that she was having a worker named Pedro pull records and receipts to show all the work that was done in the home, again, which is contrary to previous statements made that there was no work done in the home.
So, did you want this introduced?
I would like it introduced. I know that they need
Any
time
objection to
to
the-
look through everything.
Well, I just got this
Oh, go ahead, take your, if you want to look through it.
33-page packet 5 minutes ago, and I've been here since 8:30. It's a little frustrating and kind of a trial by ambush, but
Take your time.
I have no objections to the photos. My only objection is to the image on page 33. There's no foundation of who that's from or how that was obtained.
Talking about the text message?
Yes.
Okay.
It's also not the complete document.
So you have no objection to anything except that page?
Correct. And just the photos.
Oh, yeah.
I object to everything else on
Okay,
the fact that it's kind of a narrative and not, but as far as the images go, I have no objection.
I got it. Let's say the city.
The, yeah, we don't really need, Your Honor, I don't believe that we actually need the text to prove the violation, so.
Well, I'll tell you, I was going to sustain the objection on that page, if you want to withdraw it. I'm going to admit pages 1 through 32. If the city wants to withdraw 33,
we're
otherwise I'm
withdrawing.
going to
We're
sustain the.
withdrawing, on this one, we're withdrawing 33.
Okay, I'm admitting pages 1 through 32, but page 33 I won't consider.
Okay.
Hey, does the city have anything further? Would you like to cross-examine the witness?
Yes, please. If you wouldn't mind turning to page, slide 12. You first sent the notice of violation by mail on July 31st, 2024. Is that correct?
Yes,
Did you receive that back as a return mail?
yes,
You sent the notice of violation certified mail on August 2nd, 2024.
yes,
Did you also receive that back?
Yes.
As return mail? And then the notice of violation wasn't posted at City Hall on the property until August 15th, 2024, is that correct?
Correct.
And then the notice of hearing wasn't sent until September 4th, 2024?
Correct.
And was that returned?
I don't believe it was returned.
And it's possible that it hasn't been returned because it was only 7 days ago.
Correct.
And there was some previous hearings where you gave testimony on the notice you provided. The Japanese Steakhouse, they received notice of the hearing today on July, it was sent to them on July 11th and July 12th, 2024, is that correct?
Yes.
And Ms. Argon was sent notice of her hearing on August 23rd, 2024, is that correct?
Yes.
But my client only gets a week notice of the hearing? And I'm going to object to the commentary from the peanut gallery in the back.
Well, I can't hear it, so you can, I'll ask everybody to please be quiet, but I can also tell you, I can hear you, I can't hear anything else.
So my client was only provided a week notice of the hearing today?
They were previously notified verbally and through email and through actually a previous notice of violation that was not accepted by the judge to get the permits for the work that was completed.
But the notice of hearing wasn't until September 4th emailed out, correct?
Which is within reason.
7 days. And you don't even know if it's been returned or not, correct?
It hasn't been returned.
Do you know where Ms. Thomas lives?
I do.
Where?
At the Winslow address, which I have previously sent mail to that you also objected to.
And I've previously said that you can send emails or mail to my office and I can accept that, correct?
For the previous case, correct.
And did you send anything about this case to my office?
No, I did not know if you were still their attorney. As I said, they did not contact me.
Well, let's cut to the chase on that. I mean, you're here, that's one thing we know, but are you asking?
I'm setting the stage for my client had to drive down from Tennessee last night on late notice.
Well, I got you, I understand, but the issue becomes prejudice, and prejudice is cured by a continuance. Are you asking for a continuance?
Yes, I would ask for a 1 month continuance. I had a large discovery, and let me double check that with my client, but she's okay with that before but I'll withdraw the request for the continuance.
Okay.
On slide 21, with the various, the diagram from Sojourn Property Ventures, that doesn't say when any of that stuff was installed, does it?
It doesn't say that it was installed, it just says that it exists.
Do you know when this property was built?
Actually, we do if you go back to property search. I think it was built in like 1963. The next slide. No, I didn't include it. But you see that it was first purchased there in 1972, so it's fairly old.
Okay, and that's the first record that's on the property appraiser's website, correct?
Correct.
So it could have been built prior to 1972.
Absolutely.
Could have been built in 1952.
Sure.
And this section of the code that you're charging my client with violating, do you know when that was enacted?
Do I know when the code was made?
Yes.
No, I do not know.
Would 2001, December 6, 2001 be a reasonable time?
Would it be a reasonable time? I don't know.
You don't know.
I don't know.
So you don't know when the code that you're charging my client with violating was even enacted?
I think we've always required permits though. But no, I don't know when the
Do you think
code.
that or do you know that?
I'm sorry, what?
Do you think that you've always required permits or do you know that you've always required
We have required permits for at least the last 10 years.
So it's possible that this work could have been done before 10 years ago?
That is not true because the windows were observed in 2020.
You observed the windows in 2020?
No, they're the pictures from the MLS.
Okay, so then, and the MLS is public, correct?
Correct.
It would be posted to websites like Zillow, Realtor.com,
Yes,
various real estate agents' websites?
yes.
So anybody can go log in and see that, correct?
Anyone could see it, yes.
Do you know what kind of property this was when it was sold? Was it kind of a willing sale? Was it a bank selling it after foreclosure?
I believe from previous disclosures, it was a foreclosure sale.
Do you know when this work was even done?
It was done after 2020, and the home was purchased in 2020.
Do you know who did the work?
I'm assuming it was the owners, but no, I do not know for certain who did the work.
So you're sitting here charging my clients with violating this portion of the code, but you don't even know for certain if my clients did it?
We charged the owners of the property, correct?
And you don't even know for certain when the work was done?
It was done after 2020,
So it could have been done any time within that 4.5 year period?
correct?
But you don't know when?
No,
And the city could have gone on and seen this on the MLS website, couldn't they have?
which part? I'm sorry.
The city could have seen that there was a potential change in the property on the MLS site?
Yes. I mean, only until it was either listed, we couldn't see a change in the windows, or until we did the inspection. And that's how we saw that there was a change in the property. If that makes sense.
This property's right on A1A, isn't it?
It is.
And it wouldn't be a hidden fact if somebody was getting windows done, if there'd be a truck and workers outside.
No,
And the city or city employees would have seen that, right?
they potentially could have.
And in the photograph on slide 26, how far away from that wall is that photograph taken?
I have no idea. If you want, like, in feet?
And you wouldn't know if there were electrical boxes behind that drywall, do you?
No. Other than that, I don't see an electrical box. I don't see anything on the wall.
It's possible that there's an electrical box behind the drywall.
I don't know. I would have to ask maybe someone from the building department. I'm not trained in inspections like that.
But based on this photograph, you don't know whether or not there's an electrical box behind that wall.
Yeah, I guess I don't know what's behind the wall at all.
And you don't know if under the carpet there was already a plumbing fixture either.
No, but to get to the plumbing, you would have to do construction work.
And you would see that construction work at the house right on A1A, right?
No one's sitting and spying on the house for 4 years straight, so no.
Right?
For the last 4 years,
Just for the past 6 months?
just the last 6 months when we became aware of the violation.
And so, to be clear, there's a 2019 MLS and a 2020 MLS that you pulled photos from?
Yes.
Do you know when my client purchased it?
It was purchased in 2020. That's on the property search. I have the deed and I have the taxes that were paid.
And you picked and chose which photographs from the MLS that you use in this presentation, correct?
Yes, I only chose the ones that I noticed there were a change from.
I'm going to remake my motion for the continuance based on the late notice of hearing after consulting with my client.
What say the city?
Your Honor, we object to that. They received the notice 7 days ago. Had they not been able to attend, well, they obviously were able to attend. We've already started the hearing. I don't necessarily want to come back in a month. Not that the city needs to pay me to come back in a month.
Outline the prejudice that you're asserting to me.
I wasn't made aware of this hearing until I believe last Thursday. I rearranged my schedule to be here today. I've had a bear of a discovery project that I just received all of the documents here this morning prior to the hearing. I think that a continuance with, and again, the other hearings that we had this morning were provided much more than 7 days in advance. And and they don't even know if my client received it when they mailed it on September 4th. It was merely because my client sent an email through the portal that they even found out that they had this hearing today. My client had to drive at the last minute, and that the "you're here" is a ridiculous argument. Then if I didn't show up, there'd be a default and I'd lose. So I had to rearrange my schedule and show up here. And I think that there is great prejudice that is affected by the late disclosure.
What I said somewhat in jest was related to the issue of notice, okay, not prejudice. Okay, so if you were just arguing that you weren't noticed, the statement, well, you're here, that's true. Land use cases or anything like that. The prejudice is something different. And you're telling me as an officer of the court, a member of the Florida Bar, that you've had inadequate opportunity to prepare this case. That's what I heard you say.
Yes, and I just received these 33 pages today, and I think that there's a kind of once, if the full document was reviewed, I believe my client could give better testimony as to those documents.
I've observed that. Ms. Vos, I'm inclined to,
Okay, that's not a problem. I'll be back next month.
when he is represented as an officer of the court and a member of the Florida Bar, that he has not had the adequate time to prepare. Usually people get a one-time continuance.
Sure.
I'll use the word right in quotes because it's not really a right. So I'm going to continue this until the next meeting, which I think is going to be October 10th, right?
Yes.
Listen to this, okay, because I have a medical procedure on October 9th, so it's going to be October 10th, which is not a Wednesday, okay? So it's going to be a Thursday. Let's see if Ms. Vos is able there.
I can get somebody in my firm to come in. I'm actually probably going to be in Michigan. But, I mean,
I'd rather be in Michigan than where I'm going. It's going to cut things off, I'm sure.
okay, so you said October 9th,
October 10th.
October 10th. Ooh. The other city attorney is Wade Bose, and he has Okeechobee, he's the county attorney for Okeechobee County, and he's got a Okeechobee County Board of County Commissioners meeting that day. And there's the other attorney who could cover it is Garrett Olson, and he's the attorney for Barefoot Bay, and he's got a 1 o'clock. But if it starts at 9, he could do that.
Let's put this first on the docket.
Okay.
Yeah.
I'd be happy to kind of work out a time, a special set time to be outside of the day after you have a medical procedure, so that Ms. Bose and myself, I know that's the last week of my wife's maternity leave, so I'm planning on being out of town for that. So I'd be happy to kind of do a special set time that we could all, that my
Well,
client could make sure she
Maybe
had.
we could work this out.
That's what I was just gonna suggest.
Hopefully we can do that as well.
What we're asking for is her to come in for an after-the-fact permit. That
Yeah.
is not the end of the world.
And this, so
I think we should
let's
be
say
able to-
October 10th, first on the docket, 9 o'clock in the morning, and with the hope that you all can work this out, because it's not an unusual case where there's after-the-fact building permits issued. There may be, I don't know if Cocoa Beach charges an additional fee, but that,
Under the
1.5
statute,
times or whatever it is, that's what most of it, 1.5 times?
I think it's double.
Double, whatever, that's normal too, so. But in any event, this isn't unusual. You need to have the permits if you ever sell the property, because you're gonna have to check a box on the listing agreement saying you got all your permits, and have to affirm that to the buyer. And this is public, so everybody knows there's not, I'm inclined to believe the city at this point that there's not permits based upon the evidence. So it sure would be good if things could work out and get the permits done.
And this property is for sale.
Well, did you say that? Okay, good. That makes me feel better, I didn't miss it. But, well, there you go, because at some point in time, either on the purchase, sale, or closing, you're gonna have to see all permits have been procured. So I'm gonna grant the continuance until October 10th, hoping that we need not have the hearing, and congratulations on being the #1 parent coming home now, right? If your wife's leave is ending. Okay? All right. The next case is case number DSCE 24-252. The respondents are Mark Soft Jr. and Mandy Thomas. The address is 104 West Leon, Cocoa Beach. This is an asserted repeat violation from a prior order that I issued. Is the city ready to proceed?
Yes.
Can we have a brief break to discuss some things with Ms. Bose?
Absolutely.
If you're,
Ms. Bo- you sure?
I think we can I think we can resolve all of this potentially.
Then that's an excellent thing to do. record.
Okay, I believe we have a resolution of.
Okay, and you could announce it, and
Yes, it's both of the cases, so we don't need to come back.
you mean the
on
repeat,
other one.
okay, go ahead. Oh, the prior case?
Yes,
Oh, okay.
yeah. So, they have
Okay, let's
agreed.
listen, and then we'll see if we have an agreement. Okay.
Okay. They have agreed to come in within 10 calendar days of today, apply for the after-the-fact permits. And also, within 10 calendar days, they're going to allow the city to fully inspect the house, all the house. After the 10 days, they are not going to be allowing anyone other than the owner and the owner's family to stay there. And if they allow anyone other than the owner or the owner's family to stay there, there will be because it's a repeat violation, a $500 a day fine. And we will be bringing that back to you if in fact someone other than the owner and the owner's family are there. And we will be, just so that it's out in the open, there are two neighbors who have constantly complained. We're going to notify them of this resolution, and they will be the eyes of the city to try to make sure that this is all, actually taken care of.
Okay. So that's the resolution?
Nope.
Nope. Yes? Nope.
Okay, well then,
Not anymore.
okay, then
Okay.
I guess we need to go forward with the hearing.
Okay.
And I believe it may be helpful to just fire me to state that on the record. Move to withdraw as counsel.
Okay.
Saying that I cannot stay at my house, have furniture.
Okay.
My brother can't be there, my son can't be there, my dad.
Okay, hang on. Time out. Let me just, let's
That's
regroup.
my rights.
Let's regroup. What I've just been advised is that you're no longer legal counsel. Is
I
that
have
right?
a right to live there.
Oh,
And I have
okay,
the right to
hang
let
on,
my
let me
mom,
take,
my dad.
ma'am, let me take one step at a time, then we'll get there. You're no longer legal counsel.
I'm mainly in Tennessee because there was a witch hunt and
No,
you guys chased me out.
hang on. I need an answer from your legal counsel, or your former legal counsel, whether he's legal counsel.
Yes, as of now,
He's what?
as of now.
He is?
Yes, as of now.
He is your legal counsel.
Yes, as of now.
Okay, then let's proceed. And you can be called as a witness later on. Are you still legal counsel?
Yes.
Okay, then you may proceed, Ms. Crawford. This is case 24-252. Unless the,
May I?
sure.
Speak? I think possibly the respondent did not understand because the settlement,
Hang on 1 second.
the
Why don't
settlement,
y'all listen to this, because there's a belief
settlement-
that there's a lack of understanding as to what the city's proposing.
okay, the settlement, my understanding was that she would be allowed to stay there, her family members would be allowed to stay there
That's what I heard.
going
And I also
forward.
heard you say I couldn't have my furniture and like food in the fridge.
No,
I'm sitting right here
no,
listening
your,
to you
your,
talk to him.
your
Okay.
attorney said that you did not agree to that, and I said, that's fine. So
Exactly, because that's what you requested, you just.
Okay, well, that's
said
not,
what
hang
you
on,
requested.
hang on.
I did, I requested that, and,
Ridiculous.
and your.
Hang on, everybody. There's nothing about furniture or refrigerator or food in this resolution that I heard. That I would not put anything in an order that was not part of the resolution. So there's nothing about food, refrigerator, or clothing, or anything like that. So do we have an agreement?
I agree not to short-term rent it out, and I agree to do. I am not doing anything that is not following the law.
And what they,
That is what I.
okay, what the stipulation sort of did was outline what would be not following the law. That's the way I understand it.
Correct, which is receiving money for a short-term rental.
Okay,
But when it comes to friends or family, or if I want to let someone just go bunk up on my couch, we all do that. I'm sure all of you have had friends stay on your couch.
Okay, I got
or
it.
family members,
Okay,
and
I got-
That's my right.
The issue, there is no resolution because of the
No,
friends.
there's
The
not.
friends is not part of the family.
yes,
Okay, so let's proceed with the case.
okay. All right.
Now, just before we go on, I know you have, but your client sort of interjected. You understand that a repeat violation can be a fine of up to $500 a day. And this property, as I recall, is not homesteaded, right? So it can be is this the property is for sale, the same?
I tried to sell it.
Well, the problem, you've told your client that this type of proceeding can cause an issue at closing, and a non-homesteaded property can be foreclosed. So if we're gonna, that settlement though is off the table, correct?
I think I don't think we have a meeting in the mind.
Okay, let's go forward then.
Okay. So this is case DSCE 24-252. The respondents and the owners of the property are Mark Soft Jr. and Mandy Thomas. The address is 104 West Leon Lane. The second slide shows property search. It's going to be very similar to the last case. This is just the property search showing who the owners are, when the home was purchased.
Well, let me cut to the chase on that. I entered an order on this case.
This is a new case.
I thought this was a repeat violation.
This is a repeat violation, so we thought we had to open a new case.
Okay,
It is a repeat violation because they have continued to rent it out. Our information is they did take it down from VRBO and Airbnb, but they were renting it out through some wedding planners.
okay, well, if I just have before me the order and any testimony there is about what's occurred in violation of that order, that's what we need.
Put both of the orders in here.
But, you all have the order. Mr. Malone?
Yeah, it's on slide 12 and 13.
Okay, okay. So you have that PowerPoint, okay,
Yes.
okay.
There are the orders.
Okay, so I have the order, this is the order I entered previously. So if the city could, enter any evidence as to why the order has been violated, the violation's been repeated.
Essentially, we were contacted by two residents saying that the property was still being rented out, that there were still guests in and out of the home. And this was after both the cease and desist date of June 7th, and then after the Massey order date of July 11th, 2024, stating that they were in compliance, they were no longer renting the property. So it was after both of these dates that the neighbors continued to see a large amount of people in and out of the home. And this is also when we received testimony from a realtor named Melissa Sachs, who is here via Teams. If you turn to slide 22. So it was on July 25th, 2024 that the realtor Melissa, she messaged Mandy Thomas the text in green, essentially stating that the potential buyer wanted access to the home that following Monday in order to have a plumber complete an inspection, at which time Mandy Thomas replied, "I'm not sure I can do before 10 without having to cancel a bunch of reservations. For a guy who has short-term rentals, STRs, he seems pretty forgetful of this." And it was also throughout verbal conversations as well that the realtor, Melissa, stated that the home is still being used, at the time, was still being used as a short-term rental. So it was after that order date.
So that is the violation that was repeated.
Yes.
Yes, yes, Your Honor, it's a continuing violation after they testified that they had stopped. And we do have the realtor on by Teams, and she can testify. And
Okay, how do we do that then?
I'm going to object to testimony by teams. I think she can be here in person, just like all of us are.
there is no legal reason why she cannot attend by Teams.
I'll swear her in just like any other witness.
Okay, how do we go about getting that?
Well, before we do that, though, do you have any cross-examination of Ms. Crawford?
I do.
Okay. So you're going to get cross-examined first.
She's on. Oh, the phone's right there. I might need 2 minutes to get her back online. I think we lost connection.
Okay, well, he wanted to ask you questions.
Oh, okay, I'm so sorry. Would you be able to get the other
Mr. Maloon,
Michael
you may
to fix
proceed.
it?
Okay, perfect.
Or try to get Melissa back on the line. I think we just lost connection. Okay, I'm sorry.
Ms. Crawford, were you a party to these text messages?
No, sir.
You don't know who actually sent these text messages?
No, sir.
But you're presenting them as evidence here today against my client.
Yes, sir.
Okay. But you don't know who actually sent these messages?
No, I
On
do
what
not.
date they were sent?
I don't have personal knowledge.
Okay. So you're giving testimony about items that you don't have personal knowledge?
That's why I invited Melissa.
And did you take this photograph on July 20th, 2024?
No,
Okay. So you don't know if that photograph has been altered?
no,
You don't know if that photograph was actually in fact from July 20th, 2024 or before June 8th, 2024?
yes, you can look at on the back end of the picture, you can look at the date that it was taken. I didn't include that,
But you didn't do that?
no.
And same with the photo from June 27th?
Yes,
And on this photograph on slide 24 from June 27th, is that taken from within the property?
no. It's over the fence, I believe, but again, I'm just assuming.
So you don't know if that was actually taken within the property or if you peered over somebody else's fence?
There's a sidewalk right there, because it's along A1A. But you're right, I don't know.
And same with the photographs from June 10th?
Correct,
And you don't know who owned those cars?
correct.
And same with, you don't know who owned the cars on the June 27th photo?
Yes, correct.
And you don't know who owned the cars on the July 20th photo?
Yes, I do not know.
I have no further questions from Ms. Crawford.
Do you mean to introduce the entire PowerPoint since we've been referring to it?
Okay. Yeah, I would like to introduce.
Do you have an objection to any of it?
I'm gonna object that she doesn't have personal knowledge of the text messages, she doesn't have personal knowledge of the photographs. The text messages are kind of double hearsay. She wasn't a party to, she didn't take the photographs, we don't have anybody here to authenticate the photographs.
Ms. Boast, do you have any comment on that?
These are complaints that were received by the city of Cocoa Beach in its normal course of business. And they are public records that we're presenting, for that purpose. Our code process is complaint-based, and these are part of the complaints. And under Florida law, they cannot be anonymous complaints, and we have revealed who made the complaints.
What about the text message?
The text messages, we're going to have the testimony of the person who actually originated those.
Okay, so what I'm going to do is I'm going to admit that the entire packet into evidence is competent exhibit A, but I'm going to admit the text message, not just that it exists for the purpose of showing that it exists, not for the truth of the matter asserted in the text message. Okay? And if the witness wants to refer to it, I suppose that's fine too, but that's what we'll do. Now we're going to call the realtor.
Yes, John.
Ms. Crawford's trying to get her on the phone or
Yes.
something. Will we be able to see her or what?
Yes.
On the screen?
On tally.
On the,
I'm not sure.
okay.
Yeah, I mean, I asked at IT,
Yeah.
make sure that, yeah,
Okay. She's waiting for, she has to work tomorrow, she needs to connect, so she's calling to try to see if she's back.
So we're going to have her on the screen, right? Okay. Because otherwise it would.
is there somebody from IT here?
She's able to speak over the phone. Her computer is not available. Is your computer available?
Well, no, we can't do that.
She can do it on the phone.
Okay, yeah.
No,
if
no,
you're
we can't.
able- If you're able to connect that, yeah, we are ready.
We're gonna, if this is gonna, this can be allowed, but we have to see her visibly
Right.
at a convenient place for everybody to see.
I believe so, yes.
As far as anything else, yes.
We can, I mean, I'd be okay with taking people out of turn and calling my client as a witness.
Okay.
That's fine. IT works it out? Okay.
Yeah, she's trying to connect now. I apologize.
Oh, so she's trying to connect now?
Yes.
Okay, let's see if we can do that then.
It'll show it right there. That laptop is me, Michael.
Well, she,
Danielle's on her phone. And, yeah.
you're not giving evidence, Mr. IT. I don't know your name, so will she be able to see us?
No.
Oh, we should be able to see her.
That's how we don't suggest
Can you arrange it? Can you,
We're going to be able to see her.
I understand, but can it be arranged that she can see us too?
So you have it set up on the, this is not the right one.
that's sort of a,
But that's the wrong one now. Right? I don't know either. This is also-
well,
Well, we didn't set up this link. This one. I'm trying to say right.
well, let me ask you this, real,
I have no idea.
Mr. IT, I don't know your name.
Michael.
Michael, hey, Michael.
How you doing?
It'd be good to see you. This isn't, he's not testifying.
Well, yeah, we're,
Is there a way, maybe not today, that it could be set up where the witness can see us too? Can you set it up so that the witness can see us too?
Possibly, yes.
Not today
We're
though,
just
right?
trying to figure out the whole joining of the link right now.
Okay, well, I think, Ms. Bose, I think the best thing to do would be to do that continuance
Okay.
until October 10th and let IT set things up. That gives Mr. Maloon more time like you asked for earlier.
Yeah.
Maybe things can get worked out in between too. Maybe things will calm down a little bit, things can get worked out. How do
can I
you,
call my client as witness now, and maybe we can get the IT issue worked out?
that's fine with me if it's fine with the city.
Because I mean, I think we have evidence.
I have
to
video
this point.
proof, I have video proof that there was no one there, and I'm happy to submit all my cameras right
Well,
now.
okay, well, hang on. Let's just call, unless the witness can be seen and see us, we can't do it. So that would require a continuance. Taking the respondent out of order makes sense to me, but I don't, does the city have any objection to that?
No, no.
Okay, let's just do that then. Okay? So, Mr. Maloon, you can call your witness.
Ms. Thomas? Yeah, stand up, there you go. Can you hear me, the court reporter mainly?
Okay, now, if you have, what I heard you say is that you have video evidence, how are you going to submit this?
I don't know, that's what I'm going to ask you, but I have video evidence.
That's the realtor, but she can't see. Oh, that's you. Who is that? Ping pong balls. What is that? What is that up there?
That's Ms. Sachs, I believe.
Oh, okay.
Which I guess, whose computer is that on, because if it's one of those laptops, it can probably just be turned around.
Who does it need to face? Does it need to face you?
Who is that?
Do you want me to sit down now?
That's the realtor?
This is the real. This is Miss Sachs and Melissa Sachs.
Okay, so if the camera's,
Sorry, I can hardly hear you guys.
ask her if she can see whoever's talking to her.
Melissa, are you able to see us?
Yes, I can see you now.
Okay, we can do this then. Okay, can you see me, ma'am?
Yes.
All right, would you raise your right hand, please? Do you solemnly swear that the testimony you're about to give in the matter now hearing but the truth, the whole truth, and nothing but the truth?
Yes, I do.
And what's your full name?
Melissa Marie Stocks.
Okay, now, we're gonna point the camera, Mr. Maloon. I want you to be able to see the witness. Well, you can, up there. Never mind, scratch that. I want her to be able to see the questioner. Okay, you may proceed, Mr. Crawford. Just go.
I'm trying to find a quiet spot to go. So sorry.
Oh, good morning.
Can you point the camera to Ms. Vos? There you go.
Hi, I'm Becky Vos, and I'm the city attorney for Cocoa Beach. And are you a realtor in Florida?
I'm sorry, are you speaking to me?
Okay. Can I come
Are you
close?
asking if I might be in Florida? I'm in Cocoa Beach, yes.
Okay, thank you.
Thank you.
Let's see, I'll get down here.
Down here.
Okay.
Sorry, I have good one, and now I know back of a restaurant and trying to help here.
Oh, thank you. We really appreciate your cooperation and your assistance. Are you a realtor in Florida?
Yes.
Okay. Were you involved in the potential purchase on behalf of a client of yours of the property at 104 West Leon Lane?
Yes.
Okay. Did you have a number of texts with Mandy Thomas?
Yes.
Okay, and were those texts related to 104 West Leon Lane?
Yes.
Okay, and did you actually have conversations with Mandy Thomas?
Yes. With my client as well.
Okay. And were you informed that the property was being used in July as a vacation rental?
I was informed and I also saw it with my own eyes, yes.
Okay, and describe that to the special magistrate, please.
Well, I have seen multiple units, and even though I sold for 7 years in Cocoa Beach, and it was the reason that my client moved down. Of course, we did our due diligence, and I called the city, and then made sure he called the city, which is why he canceled the deal. But up until then, we believed that, even though I saw multiple parties going in and out of the property, that she had no issues with the city, that all of her plumbing was updated, and that she was Airbnb 6 separate properties in her home. And because I've never run into that before, I didn't immediately know that was allowed, which is why I called the city. The reason I'm here today, if I may, is because she's decided, since my client canceled due to not being able to get his loan, because his loan involved multiple rental income property, she's withholding his $5,000. And that's the reason that I'm here today. I don't want any trouble. You know, I'm not trying to make any trouble for anybody, but I'm here because she won't get my client back to escrow.
Okay.
And now she's in litigation.
Okay. And do you have personal knowledge as to whether there were rental multiple units in July of 2024?
The only knowledge I have is standing there seeing two separate parties come in. I met a young woman who was in a third unit. Her name is Tiffany. I was told by the homeowner, Nick Kennedy, that she pays her $1,200 cash a month, and that my client should consider keeping her, that she'd be willing to move to any part of the property if he wanted that particular unit.
Okay. And were you told that there were other units being rented at that time?
Oh, I was completely ripped a new one every time I tried to have an inspection, and told that my client, since he has short-term rentals in the state of Missouri, he should understand how we're inconveniencing her. She mortified and embarrassed me in front of my client, and I just kept my mouth shut until I have the time to call the city and speak to Danielle and become informed, and then inform my client, even though he spent almost $2,000 in inspections at that point.
Okay, and was the reason that you weren't allowed to schedule the inspections at will was because there were renters in the property?
Well, respectfully, we always want to make sure we accommodate the seller. She did not live there. The inspector had asked me about, I think it was 8:30 or 9 a.m., and she had said that is not okay because there are people checking out, and my client should know better. And I explained to her the inspector requested the time, but I would happily change it to 10 or whatever she wanted, and that is what I did.
Okay, and tell me what the time frame of these interactions were.
They were all probably within the first 2 weeks. I'm very sorry I don't have in front of me the date he went under contract. We did cancel with the lender letter within the 30 days, which is a loan contingency. So there's no legal reason for her to be upset or hold his money. Unfortunately, things happen all the time. But this particular client only wanted to do short-term rentals in our beautiful town. So the time frame was all, I could look it up, but it was all within probably the first 9 to 12 days.
Okay, but that was in July of 2024? Or
Yes.
August? Okay, July. What part of July?
Again, I'm sorry, I have to look at the contract to see the exact date, but it was all within a week or two of having signed the contract. We offered $50,000 over the asking price, even though she told us that she had a cash buyer and her brother wanted to find a way to cancel this deal so they could take a cash buyer. I did everything I could to try to make the deal work.
Did you give a series of texts to Danielle?
I did. She asked me for them, I snapshotted them, and I also came down to the city so she could take my phone and look at my phone and read the dates and, verify that they were real. I was trying to help.
Okay. And the dates and the snapshots of your texts, did you alter them in any way?
No, of course not.
Okay, all right. And there is a text message, I'm reading it, it says 104 West Leon at the top. It says text message Thursday, July 25 at 1:52 p.m. It says, good morning. The buyer is doing one last inspection. He's having a licensed plumber come in. He will need access to the house at 8:30 a.m. on Monday. Please let me know that that works for you, and if you want me to allow access, I will do that. Do you recall that
Yeah.
interaction?
Yes. I don't work with a lot of for sale by owners, and being the only licensed real estate agent, I wanted her to feel comfortable that if she couldn't meet me at the property, that I was a licensed real estate agent and I would keep her property safe and she didn't have to go out of her way to let us in.
Okay. And there, on the text that you gave to Danielle, there was this response that says, I'm not sure I can do before 10 without having to cancel a bunch of reservations. For a guy who has STRs, he seems pretty forgetful of this. Do you recall receiving that text?
Yes.
Okay. And STRs, does that mean short-term rentals?
Short-term rentals, yeah.
Okay.
And there was a phone caller too, where she, verbally attacked me and told me I didn't know how to do my job, and I never said a word to her. I tried to accommodate her so I could protect my client and get what he wanted, which was at the time to purchase a house.
Okay. And so your testimony today was on July 25th. She was actively having a bunch of reservations at the property at 104 West Leon. Is that accurate?
Correct, yeah.
Okay. All right. That's all I have. The attorney for the other side may have some questions for you. Or the special magistrate may, I don't
Now,
know.
Mr. Maloon, you proceed.
Yes. Good morning, Ms. Sachs. Where are you currently located?
I'm in Cocoa Beach.
But what part of Cocoa Beach?
I live in a condo right near the Hilton. I met a client for coffee, and I'm currently at a restaurant across the street.
How far are you from the golf course in Cocoa Beach?
I'm not far from the golf course. I'm currently downtown Cocoa Beach.
Okay, so
I didn't still be in the same room with the seller. If I'm being honest with you, she's been very angry and aggressive toward me, and I don't know her. So my daughter lives with me. I'm a little bit uncomfortable to be in the same room with her. I don't know if she's there, but that's truly how I feel.
so you just didn't want to be here today. You just wanted to appear remotely. Is that fair to say?
No, I had originally planned to be there, and then I just thought about it because I don't want to create a problem for anyone, and I don't want to create a problem for myself. And like I said, my daughter lives with me, so I said to Danielle, I'm not comfortable, and she offered for me to be able to do this on Zoom, and I said yes.
And you stated that you're only doing this because my client is refusing to return the earnest money deposit to your client, correct?
Well, there's a twofold reason. The city's always been there for me. My clients have always gotten the right information, including this time. I've never been asked to do anything for the city. My client is devastated. He's lost a lot of money in this deal, from over 1,700 in inspections, over 1,000 in attorney fees, and for absolutely no reason not having his $5,000 escrow returned. So yes, I am a little bit feeling that she did the wrong thing here, and I guess I would go out of my way to assist the city in trying to do the right thing, which is, I'm guessing, follow your rules.
And you will personally benefit by the return of the earnest money deposit, won't you?
100% no. I've spent dozens of hours working with my client. As a matter of fact, I've spent 5 years trying to find him the perfect property, and I've gotten 0 cents out of it. 0.
And if the earnest money deposit is returned, would you get a benefit out of that?
I just told you no.
What days were there renters at the property?
I have no idea without that being in front of me, but it looks like the 25th and any other days.
Okay, so you have no idea what days there were actually renters at the property, but it looks like other days, correct?
I saw at least 2 separate parties pull up while I was at the property.
On what days?
I don't know, around the 25th.
That's awfully convenient. You're also not here in person, right?
I don't know why you think you can speak to me disrespectfully, but I explained to you why I'm not there in person, sir. This fight is not with me.
So you do not know what days you saw these people here, so there's no way for me to go and look at video of who may have been there, correct?
Sure, correct.
And then, I don't know if you have the text messages with Mandy in front of you that have been presented, but there's a text message from Tuesday, July 30th at 6:59 p.m. where there's a document that's sent to you, or a link from the Pier, Wedding, Reunions, and Large Groups, right?
Yes.
Do you know the address for that property?
I do not. She was sending us lots of information on many properties that she has in Cocoa Beach, where she fronts to a lot of people, including, in her words, she had 2 or 3 units at 126 Alachua. She also said that the reason she's selling is because she's going into another project in another state, but that she would have been very interested in going into a wedding party venue, and that it would have made her a lot of money.
And in the text message on page 8, it's a long text, but there's, and it's the white text, I believe it's to you. It says, I was in the process of connecting with all the wedding planners in the area, correct?
I recall something like that, yes.
That doesn't say that it was currently being rented out for wedding planning, does it?
I don't think so. I mean, you're reading it.
Did you see Mandy's, any transactions from Airbnb, VRBO on those July dates when you supposedly saw people at the property?
I definitely saw people at the property, and I would not be privy to many of her personal transactions. She did send us a spreadsheet from QuickBooks showing that she made $180,000 in 2023. I can get that over to Danielle shortly if you'd like.
But nothing from 2024 after June 8th, right?
I don't know the dates. I just sent them to my client to show him. I wasn't investigating her. I was trying to sell her house for her.
And then there was also some reviews that were sent to you, correct? Do you recall those?
Not specifically, but yes, probably.
Were any of those from prior to, June of 2024?
I have no idea.
You don't know.
Correct.
And then after that, you asked, oh, is this Alachua, correct?
No.
You didn't say that.
The city, if I may, I originally asked Danielle or whomever, I don't understand what's happening. She's telling me one thing, you guys are telling me another. Danielle had sent me several documents with some issues. And then when I sent them to Mandy and her attorney, she said, oh, seriously, this is for the wrong house. So I said to Danielle, oh my God, I think this was for her other house. And Danielle said, no, it's not. The only place that she receives mail is 126 Alachua. We're not able to get mail to her or something like that.
Okay, so when
I fight.
Mandy sent a link on here, said my whole house listing with 4 micro units, and then you said sent to him. Do you recall that?
Yeah, I believe that was from the other house in Cocoa Beach, not Alachua or Leon.
But you asked, this is Alachua, nice? Correct?
Oh, that's what it says, but we had 100 texts, and everything that she sent me that I thought was positive, I shared with my client. To show him what a beautiful community this is to live or to have a rental out of your home. So yeah, that's my job.
And then Mandy said back, no, this is Winslow. I have Winslow cross-advertised on about 15 sites. Alachua, I'm doing more midterm rentals, correct?
Yes.
So Mandy didn't tell you that she was doing short-term rentals, correct?
She told me she had 6 separate short-term rentals at the house I was trying to sell for her. 104 West Leon. I was the first agent to call. We did over $50,000. My client flew in from Missouri, and we placed $5,000 down in escrow of his money, ordered a bunch of inspections, and I called the city as soon as I could and told him he also needed to do that, because I do that with every client.
Again, but Mandy here texted you that Alachua, she was doing more midterm rentals, correct?
You've already said that. What's your point?
You didn't answer my question.
Well, I said yes, I believe so, but I mean, I don't know. I don't even know what that means. I know she had at least 2 different people living there, but it's none of my business. I don't know.
Okay, it's none of your business, but you're here testifying against her today, correct?
I'm here at Danielle's request to say that the texts are actually on my phone. That's it.
One moment.
Ms. Crawford, there's a bunch of texts that are referred to. Were all the texts in the PowerPoint?
No, I had them separate because I wasn't sure if we needed them. But I can give you texts.
No, that was okay. Thank you.
Just a few more questions. Did you ever see workers at the property?
I don't recall.
Okay. If you don't get your client his earnest money back, he's going to be kind of upset with you and probably wouldn't work with you in the future, correct?
It doesn't really matter to me. What matters to me is my reputation in this business. There's no legal reason for his money not to have been returned to him, so I've done everything I can, including help him find an attorney with no reward to me other than doing the right thing. So like I said, I was asked to come here today to tell the DA that my phone has those texts on it. I wasn't prepared for a line of questioning from you.
So you just wanted to give your side of the story without being cross-examined, correct?
There's no side of the story. I was asked to show some text. I brought my phone down there. And then I was told, well, they won't use it, you need to come, and I said, I don't feel comfortable, and she said, we can do a Zoom link, and that was it. It's not me against Mandy. Again, I gain or lose nothing from this. Every fear of doing the right thing? Absurd.
But you care about your reputation, correct?
Yes, I do, and I care about my clients. Would you like $5,000 stolen from you for no reason? When you were lied to? That's how the client feels. And I've never sold the property or made a single penny off of him, ever.
You testified earlier that your client canceled the contract, correct?
Yes, he was denied the loan.
But he canceled the contract, correct?
Yes, based on the lender denied. Correct.
No further questions.
Okay. Ms. Bose, do you have any other questions?
No, Your Honor.
All right. Thank you very much, Ms. Sox. We appreciate your testimony.
Are you done with me?
Yes. You go enjoy the rest of the day.
Yes, thank you very much.
Thank you. Have a good day.
You too.
Yeah. So all the text Ms. Crawford, all the texts that were referred to, and Ms. Sox basically authenticated, that you want those to be
Yes, if those could
accepted
be,
into evidence too, correct?
yes, please.
And Mr. Maloon, you have no objection to the text you were referring to there?
No objection.
That would be Exhibit B of the city. Does the city have anything further in this case?
No, Your Honor.
Okay, Mr. Maloon.
I now call Ms. Thomas. Is there a way for me to send emails and videos to that computer to put them on the screen?
Michael. Where's Michael?
From my understanding, no.
Where's Michael?
I can go find Michael. You can.
Maybe we could Teams in and share our screen?
Oh, yeah, absolutely. Yeah.
Okay. Now, I want to save those two for evidentiary purposes, so why don't you email them to Ms. Crawford? Can you do that?
I'm in the process of getting them now.
Do you want me to get somebody from IT?
Well, you would like everybody to see them on the screen, right?
That would probably be easier
Yes.
than crowding around the phone.
There's Michael. We got two Michaels today.
We have them right now on the file. Yeah, we can go into your phone, then I'll email them to myself.
How does the court reporter show this? Everybody confusingly looked at the IT guy.
Yeah, I'll do that.
That's what is it, Gmail or Yahoo?
It's a,
Outlook? Then, yeah.
I'm getting them.
Let's see.
So you guys done with this Teams meeting?
I was just inviting Mr. Maloon in case he wanted to join to share.
Let's keep that open, just in case this doesn't work. Because I know we have all sorts of crazy kinds of IT, like I
I'm
do.
on my Outlook account though. So we would have.
Log
to
out, yeah, log out and then I get.
What I'll do is.
Thomas, and I got lunch for everybody at City of Cocoa Beach.
That works.
Let's do a text. I'd say it's stupid. You with IT probably. Appreciate that. Mr. Mac. But you're probably better using. Yes, while I'm opening these up, I can call Ms. Thomas and begin asking the
Okay,
questions.
that'd be fine.
I'm actually sending you.
Oh, you're the one, okay, perfect. We're, never mind.
Okay.
Just trying to get it to you fast. I'm sending the 24th meeting to it, she's sending the 25th.
Yeah.
That mouse touch is very,
So cool to do. And then what I will do with these is I will, because there's so many of them, I will upload all of the emails and the links to a OneDrive to Ms. Bose and to yourself.
Okay. Whose email is it going to?
That's my email.
That's yours? Okay. Is that acceptable to the city?
It is.
Okay. Appreciate that.
Yes. Just those. I may use the rest, we'll see. I guess I like the AC on like SeaWorld level here. Like SeaWorld penguin level.
Me too.
Ms. Rose will be right back.
Excuse me?
Ms. Rose will be right back.
Okay. We'll wait. This air conditioner will put you to sleep.
I love the cold. This is fine for me. I don't know why I still live in Florida.
Is that chair yoga out there?
Yeah.
Funny. Never seen chair yoga before.
Brings a different meaning to all fours. Brings a different meaning to all fours. Sitting at the fours.
There's a Madam Court reporter. You not interested in chair yoga?
Say what it is?
That's what I've never seen it before. I don't think you'd work up a sweat, that's for sure.
Not moving very fast.
Go. Oh,
Mandy? Good morning. What is your name for the record?
Mandy Thomas.
What is your relationship with the property at issue?
My brother and I own it.
Since June 8th of 2024, have you short-term rented this property?
No.
There was a text message that was discussed when Ms. Sachs was testifying, where you said that you didn't want to have the person come early because you have to cancel rentals. Why did you send that?
I travel almost 12 hours up here. She was a little on short-term notice. I honestly just didn't want to get my ass up after driving another 12 hours, just like I had to do again today.
And it was kind of unclear as to when when Ms. Sachs or what the dates that this was rented out, but one of the dates was the July 25th date. Can you explain what cameras may or may not be at the property?
Yeah, we have obviously security cameras. I have security cameras at my property, so we are sending you pictures of the front camera, which shows the parking lot and that would obviously, if I was renting, especially to a wedding party, which a wedding party is very large, you would see vehicles coming in and out. You'd obviously see people coming in and out of doors. It's the main entrance, so if you're not coming in and out of that entrance, there's no one there. So we started sending you a large amount of videos dating back to the 24th, showing that no one was there on the 24th. No one, in fact, stayed there the night of the 24th, which then would have led into the morning of the 25th, and so on. And you'll see Lisa, you'll see Cheyenne. That Jeep right there belongs to my son's father, and I'm not even sure if it starts. It doesn't move. You'll see Melissa, and I would have to assume it was the inspector in some of the videos because he's up on the roof, and Lisa's actually working on sending you another video. We had started moving items out. We're trying to get you a video of a washer and dryer also that we pulled out that day.
Who is Cheyenne?
It's Lisa's daughter. She helps keep up the properties, pick weeds, blow, things like that.
And I have this. Do you know what day this video was taken that I currently have playing on the screen?
If that was sent for me, it would have been the 24th. If it was sent from Lisa, it's the 25th. There should be a date on there. Otherwise, we can send you screenshots of all the dates.
So I'll do this. Sorry, I'm having technical difficulties. Now I have Michael leave. So this one was sent from you, so this was from the 24th?
Leading up to the 25th, because if there was somebody there at 8:30 in the morning that I quote unquote would have to cancel, they would obviously be there the 24th then.
In this 20-second video from the 24th, other than that Jeep, are there any cars?
No, not in that picture or video.
I would move this into evidence as Exhibit 1.
Any objections?
No, Your Honor.
So admitted.
And then the video that you sent to me, number 2, was this also from July 4th, 2024?
24th.
And again, there's nobody in the,
No.
I'll put that, thank you. That's a lifesaver. And I kind of, to be, which way is this camera facing? Is
The
this
house.
facing to the north?
Yes.
So this would be, kind of, again, not that you're a solar expert, but mid-afternoon?
Yes.
I would move this into evidence as Exhibit 2.
Any objection?
No.
It's so admitted.
Moving on to the third video. I have a mouse now. It's a lifesaver. The third video that you sent. What does this video show?
Same video. No one currently there.
A little later in the afternoon with the longer shadow?
Yeah, I mean, later, because that's how I sent them in 1, 2, 3, 4. I could give you the exact times as well. Actually, they're right there.
And down at the bottom, there we go.
Yep, dates and times.
Yeah, let me see if
I just saw them too. You saw it when you shrunk it
I
up.
did. I believe it was 5:08, and let me see if I can get this to come back.
There you go. Yep. Did you click on
There it is. There it is.
There it is.
8:34 ET and 7:24:24.
And that would be, well, that would be 17:08, 41 Eastern Daylight Time.
Yes.
I would move video number 3 into evidence as Exhibit 3.
No objection.
And with video number 4, what time was this taken?
17:36 EDT and 7:24:24.
Anybody in the parking lot?
No,
Any renters?
no.
I would move video 4 into evidence as Exhibit 4.
Any objection, Ms. Phillips?
No.
Those will all be admitted.
And then this video, which is from 1810, is this the same?
24.
And nobody in the parking lot?
Nope,
No renters?
nope.
And this was, I'll move video 8 into evidence as Exhibit 5.
8,
No objection.
admitted.
I think I only sent one more. At 9. And then you told me to stop, but there's more, obviously, into the night.
Does the ring get triggered by the bush that's moving and the traffic on A1A?
I have it set on a very delicate setting. I swear I think a palmetto bug could fly in front of it. Change my batteries pretty often.
And there's video number 9 that you sent me from 6:30.
No one there.
Nobody there? And then this video that was taken on July 25th at 15:43, what does this show?
This would be the day after. No renters there. The garage door is open. So either one of two things were happening at that day and time because Melissa was there with the inspector. He's either walking around, and I do believe that you will see Lisa and Cheyenne walking around with a leaf blower. And Cheyenne is Lisa LaRue's daughter.
That's number 9, right?
This one, I would like to move number 9, which was the previous video from the 24th, into evidence as Exhibit 6.
Any objection on number 9?
No.
What's this one?
This one is no subject, but we'll call it the video from, let's see, let me get it playing. 3:43 on the 25th. I'll move that into evidence as Exhibit 7.
7?
Yes.
Okay.
No
Object?
objection.
There's Cheyenne with the leaf blower, as I mentioned.
This was from 3:35.
Yes.
I move the 3:35 video into evidence as Exhibit 8.
Okay, what you have now is 1, 2, 3, 4, 8, 9, and 7.
Correct.
Want to make that 6?
So video number 8 was Exhibit 5, video number 9 was Exhibit 6.
Okay,
Decided to
I got it.
try and make things.
Seven, okay, I got it. Or 8 then, got it.
And this video is from 2:04 on the 25th. Whose car is that?
Lisa LaRue's?
Was there anybody else at the property at this time?
Nope, garage door isn't open, so that means Cheyenne wasn't there yet.
I move the 2:05 video into evidence as Exhibit 9.
No objection? Okay, it's admitted.
That appears to be the same one.
This one is, it's also Miss LaRue driving in, but it's at 12:20.
Yes.
I would move this one, the 12:20 video into evidence as Exhibit 10.
Objection?
No, none.
Admitted.
How many, and I know we kind of had a brief amount of time, but how many, have you reviewed other videos than what we've presented as evidence today without having to sit here for an hour and go through days of video?
Yep, we went through about 3 days while we were sitting there trying to send as many to you as possible.
You can kind of scrub back and forth pretty quickly over the videos. In those videos, were there any short-term renters at the property?
No,
Did you receive any money from any short-term renters in July of 2024 for the property?
no.
What effort did you have to make to come to this hearing this morning?
I drove through the night 12 hours to be here because I work up in Tennessee. I have real estate up there with my brother, and we're trying to get a campground up, and I had to stay there as long as possible because I had a power pole put in and then drive through the night.
And you're aware of the special magistrate's order and the stipulations to not rent past?
Yes.
You need to explain that to her.
Yes, I can send videos of us even moving out washers and dryers. I think Lisa was,
I think the last one I sent you was when they're moving out one of the washers and dryers.
I don't know what was said from the audience, but that wasn't testimony.
No.
it's not on that one. It would have been right away, Nathan. You'll see a vehicle with a washer and dryer. No, go to your last one. There.
So this photograph, this video is from July 23rd at 4:31,
Yes,
and these were individuals that were moving the washer and dryer?
yes.
Why were they moving the washer and dryer?
Don't need washers and dryers if I'm not short-term renting out a property. I'm gonna take some of them to Tennessee, sell some of them hopefully with the property. Otherwise, they're going up on Marketplace.
You had we went through some text messages between yourself and Ms. Sachs. And there was a lot of discussion that you had about wedding planners. Which property was that you were using for weddings?
So when I sent her reviews and descriptions, it was not for either of the properties. It's not for any properties within the city of Cocoa Beach. And I was explaining to her when she was talking about her client wanting to use it as an Airbnb, I stated that that house, because it's a spread out multi-generational type home, that it would be well suited to do weddings because you could have like a bride and groom, you know, one part of the house with their own space. You could have the bridesmaid with her hubby, and you can have 8 people per their Airbnb, their new Airbnb codes. And they could all stay there, you know, without being on top of each other with privacy. And if we kept the property, my brother and I had debated if we were going to do that, but as I've stated, I feel like there's a little bit of a witch hunt and we're just trying to bail.
What is your current goal with the property?
I tried selling it, and I feel like There were some not truth statements made and things that were, they sent information on Alachua to her, which they weren't even looking at, just to prove that supposedly I'm not compliant and that these properties are all sorts of issues. And then, so they pulled their offer. Otherwise, I would have been out of their hair, out of Cocoa Beach, and gone, because it would have closed by now.
What is the reason that the contract, what is the reason that you're making the claim to the earnest money deposit?
They ended up canceling it after, well, she called me and sent the letter it took a couple days for them to actually get the official letter of cancellation, but she had sent me a text message, and the same messages, if I knew we were talking about this, I would have entered those into evidence. She stated that she had a conversation with the city of Cocoa Beach. She started sending me all of the documents, which included other properties, which, is not cool. And they were pulling out because of that reason, because of what the city told them. And that's a quote in a text message.
I just want to be super clear, you have not short-term rented out this property since June 8th of 2024?
Nope, haven't received a dime from it.
No further questions.
Ms. Bosch, you have questions?
Yes, on this, can you leave that up?
Yes.
Do you have another camera on the other side of the building where the doors are and the other part of the parking area is?
Yeah, we can send more footage if you would like.
Okay. Is the parking area over there?
This is where all the when I was short-term renting, this is where all the short-term rentals parked.
Okay, and who parked over on that side?
It would either, so I kept the front spot for like myself and my brother, Lisa, people like that. And then when I was first here, like I had told you, I had a gal that was staying there long-term, month after month after month as a roommate. She was over there.
Okay, so how many parking spaces are on that side?
I guess you could try cramming in multiple, but typically we would have only said 2.
Okay, because you named a lot of people, you said park there.
Well, sure, yeah, people come in and out, right?
Okay.
I keep the front spot there, so I can come in, Lisa can come in, but that was where, when I was short-term renting it out, and you can even see the blocks there, and actually they're even, you can see the blocks there on the vehicles, so that's where we parked them.
Okay, and you do have other videos of the
Yeah, and I'm happy,
parking
to
spaces?
share them with you.
Can we at least see a couple of them from that day?
Sure.
Sure.
What day? Because I sent 2 days.
Huh?
What day? I sent 2 days. So you want 23rd, 24th?
The 25th.
I'm sorry, 25th.
She said that it was the Monday following the 25th, but she would have to cancel this.
Oh, it was the Monday after the 25th.
Give me a date and I'll get it to you. I don't see
Yeah,
that on
because-
the ring camera.
Because the text was talking about, because I think where we were looking at the wrong dates.
I mean, I can find right when Melissa's there and I can send that video if you'd like to. Does anyone have? the
So it
video?
would have been the 29th.
29th?
You could send some from the 29th on both sides of the building.
Is that the date of the inspection?
Yes.
Sending those videos, if you want to start pulling them up and put them in.
You want me to keep up the other videos?
Okay, whose car is this?
Those were my movers that you saw earlier. Well, what date is that? That's John's. Yep, see, those are the movers right there, with the washer and dryer.
Okay, so you moved washers and dryers on 2 different days?
Then he's just pulling up the same video. I'm not supposed to see.
Did you send some videos of the other side?
Yeah, working on it right now.
Yeah, that's the one I have up right now.
That's not the other side, that's.
No, it's not, Nathan. The one that you just pulled up is still up in front. You should get one. It'll be marked as 1 and 2 I just sent.
Okay.
I think I might have double sent one.
Okay, there are a couple of vehicles there.
This is the day of the inspection. And you'll see in some of my videos that they're definitely inspectors because they're up on the roof.
Okay.
You want me to play this video?
Actually, that smaller vehicle belonged to the realtor. Because she always parked right there, she has a car on the side line.
Yeah, was this before 10 a.m.? Check.
I believe it was at 11. I guess you guys can, it is tiny.
Does anybody want to introduce that?
Okay.
Mr. Malone?
I'll introduce him into evidence.
Objection, Ms. Post?
No, not
Got
at all.
11 now.
And, Your Honor, I believe that at this point, I think we're going to withdraw this case.
Okay.
The-
No, I think they
Oh,
withdrawn
I'm
it.
sorry, I was watching
Yeah.
and listening.
Yes, and
When you say withdraw, you're going to dismiss
we
the,
are dismissing it.
okay.
And we just in defense of the city here, we did receive complaints from 2 different neighbors saying that that this was going on.
Well, there was an inference from was it Mr. McFarland? So the case is dismissed, okay?
Yes.
But there was an inference from was it Mr. McFarland who took photos? There was an inference that there was a violation, okay?
Yes.
So there should be, the city has to act on complaint-driven system.
I
okay?
understand, and unfortunately, neighbors, there's things that you guys don't know in between neighbors, and it's
Well,
very
that-
easy to make a complaint.
It's jurisdiction, this is not the only jurisdiction that has people complain about one another.
No, I know,
Yeah.
like I say, I understand.
Okay, so the city has dismissed the case
Okay, we still need the after-the-fact permits
on the prior case.
on the prior case.
Oh, yeah, that order's still gonna be entered, you understand that? We're talking about the repeat violation case is dismissed.
Yes, it
Got
is.
it. Okay. All right, so the next case, though, is that also relates to Mark Soff. Are you, your brother, right?
Oh, it's not a case, I was just.
I was just saying it was a compliance, status report.
From the previous case. the
Status
affidavit
report.
of compliance.
All right,
Yeah,
Okay.
then that case is dismissed. There's nothing on the next case. Is there anything further that the city would like to bring before?
No?
Would you like to complain against, no, that's a joke.
You don't want to get me going, but thank you.
That was a very good, all right. That concludes the proceedings of the special magistrate today. Thank you very, very much for everybody's attention.